Thanks, Matt. And thanks to the partners of Paul Chadwick for inviting me along tonight to talk about the PPSA. This is one of my pet topics at the university. We've been teaching PPSA since before the PPSA began. We thought it was going to come in 2011, and then of course it was delayed several times, so we've been teaching it for going on 5 years now. I've been involved in PPSA since even before that, actually. I can remember the day back in 2009 when then Professor John Stumble said to me, "You've got to get your head around this PPSA thing." And there began a journey that's gone on for another 7 years. The PPSA, there's an awful lot to it. Matt asked me to talk about something that he thought would be quite practical. And so what I've chosen to do tonight is to look at the theme of PPSA security agreements. And basically what I've done is I've had a look at all of the PPSA decisions in the last 12 months, or roughly the last 12 months. And it seems to me there's a distinct theme that is arising in these decisions. So I've focused on 4 decisions that we'll get to a little bit later from the last 12 months that look at different aspects of security agreements under the PPSA, and then talk about the consequences of how those security agreements have been formulated for rights under the PPSA and some adverse consequences under the PPSA, particularly vesting issues. But before we get to that, I thought it might be useful just to take stock of where we're at in terms of the PPS. So I've got some statistics which I've got from the PPSR. I also want to just spend a brief moment going through what is actually required to be placed in your PPSA security agreement. So what is a PPSA security agreement? And what are some of the technical details that you have to include in them? And the reason I'm doing that is because what we see in the cases that I'm going to discuss in more detail is that those requirements haven't always been met. And that, of course, the parties don't realise that they're not meeting the legal requirements until one or more of them ends up in an insolvency situation and they're arguing over who has rights to particular property, and particularly with the operation of the vesting rule. So it's often in insolvency, so it's very apt that I'm speaking here, it's in insolvency where these issues really come to light. Until that stage, the parties think that everything's going along fine in their commercial arrangement. So it's worth spending just a moment talking about what the PPSA requires on security agreements. I'll also talk very briefly about the Whittaker Report. Many of you might be somewhat familiar with the Whittaker Report. I must confess that I have not read every page of it. It's more than 500 pages. Mr. Whittaker makes some 400 recommendations to amend the PPSA, which is interesting because there aren't 400 sections in the PPSA. So it's a very detailed report. Thankfully for this presentation, there's only 2 recommendations that affect directly the provisions on security agreements. So I'll be talking a little bit about what Mr. Whittaker has recommended there. And then at the end, I'll go through the 4 recent cases, including the Forge case, which many of you might have heard about. Okay, so let's take stock. Where are we at in terms of the Personal Property Securities Register in particular? So the PPSR, which is administered by AFSA, publishes quarterly statistics, and what we see there, this is just a summary of some of the most recent statistics, which is for the March 16 quarter. So what we see there is that every 3 months, the PPSR is recording approximately 2 million searches, and about 56% of all of those searches are for serial numbered property. Now that's consistent with about 50% of all registrations are motor vehicles. So as many of you no doubt are aware, one of the main categories of registers that were migrated under the pre-PPSA law onto the PPSR were the motor vehicle registries, or REVs. So that's certainly consistent with that. One of the things I found interesting was that only 5.6% of all searches are done by casual users. The rest of them are done by people who have an account with the PPSR, so you would assume more business users. And only 1.5% of all searches are done of individual grantors. So it certainly seems that the PPSR is predominantly concerned with commercial property and commercial dealings. And we see that further confirmed if you look at that last statistic there. 72.9% of all registrations are classified as commercial property rather than consumer property. We see about 25% are registered under the category of other goods, which is very broad. 19% all-PAP, although the all-PAP category certainly comes up in pretty much all of the cases. And as I say, about half are for motor vehicles. In terms of new registrations, the numbers are down a little bit in this quarter if we compare it with the December 15 quarter, but I think that's just to take into account the Christmas break and January break. So about 500,000 new registrations within the 3 months leading up to March. And we're at about 530,000 registrations in the December 15 quarter. Interestingly, there's still more than 3 million transitional security interests registered on PPSA, even though the transitional period ended 2 years ago. So we still have a number of those floating on the register. Okay, so that's just a quick snapshot of what we find on the Personal Property Securities Register. So turning then to the concept of security agreements. The PPSA defines security agreement in section 10, and I'm happy for these slides to be distributed as well. So on some of the slides I've got some quotes and things, so some of the text is a little bit small. So the definition of security agreement is an agreement or act by which a security interest is created, arises or is provided for, or writing evidencing such an agreement or act. So that's the PPSA's definition of what is a security agreement. The first point that I'd make here is that the PPS regime does not prescribe all of the details that you have to put in your security agreement. Really what the law is doing is it is assuming that the parties already have a security agreement, whether that be a fully written agreement, whether that be a fully verbal agreement, whether that be a mix of the two. And indeed, I mean, that's consistent with the general commercial law of contract. Not all contracts have to be in writing. Most contracts don't have to be in writing, of course. But the PPSA is not a code. So the rules that we have in the PPSA, as detailed as they are, and as I say, there's more than 300 of them, they are assuming that the parties have already negotiated the basics of their relationship themselves, and then the Act is superimposed onto that. So largely what the PPSA does is give us rules dealing with priority contests. And one of those very important priority contests is where one of the secured parties fails to perfect, and that's something we're going to turn to in just a moment. The other point to note, of course, is that Section 18 gives us this very broad statement that security agreements are effective according to their terms. Again, reinforcing this point that the PPSA is not trying to tell you what to put in your security agreement, although there are some of those rules that we'll get to, and largely it's working on what the parties have already agreed amongst themselves. And really it's about priority and enforcement rules. Okay, so you can have a PPSA security agreement which is verbal, which is totally verbal. And this, of course, is leaving aside certain legal regimes like consumer credit, where your contract has to be in writing. You can have a PPSA security agreement which is totally verbal, but you shouldn't. That's the first tip for the night. You shouldn't have a verbal PPSA agreement if you can avoid it. And the reason for that is you're then exposing yourself to a number of pretty severe legal risks. So what are some of those legal risks? The first one, and the most important one, is that if you only have a verbal PPSA security agreement, then you will not be able to establish that your security interest, so this is assuming that you're a secured party who's taking an interest in the personal property, if you only have a verbal security agreement, you will not be able to establish enforceability against third parties. And so just a quick recap on this point. What the PPSA does is it sets up a waterfall of priority rights. And the first priority right, it talks about the relationship between the secured party and the grantor, or the creditor and the debtor in most cases. And in that situation, it says the only thing you need to have an enforceable right against the grantor with respect to the property that's held as collateral is to have a security interest that has attached to the collateral. So it can be totally in a verbal contract, and that's fine. But once there's then a competing interest in the same collateral, so there's another secured party, or really any other party, a third party who has an interest in that collateral, then merely having an attached security interest is not enough. You need something else. And so what the Act then provides is, well, you can have a written security agreement and it can be signed by the grantor and it can have certain minimum content. that is prescribed. And you can then go off and register. So that's one way of protecting yourself and one way of achieving enforceability against third parties, someone other than the debtor, a competing person with an interest in the collateral. But what if you don't do that? So if you don't have a written security agreement, or you don't have a written agreement that complies with the PPSA, then what are your other options? They are few. The first one is that you can possess the collateral. Now that assumes that it's tangible. So if we're not dealing with tangible property, that one's out the window. But you can't possess the collateral simply by repossession. So really what this category is about is saying that you have always possessed the collateral. It's essentially talking about a pledge or a pawn type situation. The only other exception is where you have control of the collateral. But that's not as broad as it might seem. Control is really about intangibles and only certain types of intangibles. So each of those categories are very narrow. And what that means is if you can't fit within either one of those categories, then you have to have a written security agreement. Otherwise, you'll not be able to get enforceability against third parties, and that then means that you are vulnerable to third parties taking priority over the collateral that you have an interest in. That then leads to the second vulnerability. It will be impossible for you to perfect your interest, because perfection requires attachment of the security interest, so rights against the grantor, and rights that are effective against a third party, as well as registration. So if you don't have that second step, if you don't have enforceability against a third party, then you cannot perfect your interest. And the dangers of having an unperfected interest include you are then vulnerable to the taking free rule. Anyone can buy the collateral or lease the collateral and take it free of your interest. You are vulnerable to the vesting rule. If the grantor, if the debtor who's given you that security interest which you have not perfected, then goes into insolvency, liquidation or voluntary administration for a company or bankruptcy for an individual, you will lose your rights in that collateral. You will simply be an unsecured creditor. That's vesting. And that can operate in two ways, under the PPSA, if you don't register at all, and also under the Corporations Act if you register late, which I'll get to a bit later. As well as losing simply in a priority contest. That is, there's another secured party who has properly perfected, you will lose out to them every time. And it doesn't matter whether your interest arose before or after their interest. So there's an awful lot of legal risk and commercial risk in failing to have a written security agreement. So they're reinforcing the first tip. You should all have written security agreements. Okay, just having a written agreement isn't enough. We need something a little bit more than that. So what does the Act prescribe? It doesn't prescribe much, but it does prescribe certain things. So Section 20, subsection 2 is the main provision that we're looking at here, and indeed this is the provision that's discussed in all of the cases that I'll be coming to a little bit later. So that imposes two requirements. Firstly, that the security agreement, it doesn't have to be in writing, it can simply be evidenced by writing. But that can then create all sorts of problems about, well, how much evidence do you need? And is it all in the one document, for example? So it's best to have just a written security agreement. That particular evidence in writing must be signed by the grantor. Now, one of the issues that comes up in the cases that we're about to look at in a moment is who exactly is the grantor, or rather, who is authorised to sign for the grantor. So we'll get into that in just a moment, and there's a couple of cases that look at that. Or if it's not signed by the grantor, then it can be accepted or adopted by an act or omission by the grantor that reasonably appears to be done with the intention of adopting or accepting the writing. So we'll come back to that in a minute. So that's the first requirement. It has to be in writing or evidenced in writing and signed by the grantor. Second requirement is the written evidence of the agreement must contain these things, and that is a description of the particular collateral, and there are rules about descriptions. There aren't many, but one of the rules is you can't simply describe it as commercial property or consumer property. You have to be more specific than that. The only general descriptions you can use are either the all present and after acquired property, or all PAP, or all present and after acquired property except for specific items or classes of property, or all PAP except as it's known. So that's how you have to describe your collateral within the writing that you are evidencing your security agreement. Okay, and then the last rule is, if you are describing your collateral as inventory, it must actually be held by the grantor as inventory, so not as equipment. Okay, so that's all the technical details in section 20. You should have a written agreement. The written agreement has to have certain things within it. So what then are some of the key risks when we look at security agreements? And this is leading us into the discussion of the cases. So one of the issues to look at is, well, what's the nature of the contractual relationship between the grantor, the debtor, and the secured party? Are we really just looking at a one-off contract, a one-off piece of paper where everything is in the document, or are we looking at an ongoing relationship? One of the benefits of the PPS regime is that you can register once, and as long as all of your future supplies are within the same collateral class, then you don't need to re-register. So that's one of the things that actually saves money. There aren't many in the PPS, but that's one of them. So that's one of the things to look at. Now, if you are dealing with multiple orders, so an ongoing relationship over time, well, how might that relationship change over time? And where you're using, for example, standard terms and conditions, if you want to adjust those terms and conditions, have you given proper notice to the debtor? Have you gotten, for example, a signed acknowledgement by the debtor that they've actually received notice that you're purporting to change the terms and conditions? Now, that was an issue in one of the cases that we're about to look at. Where you are dealing with an ongoing relationship, you may well have multiple documents. So there might be, for example, a credit agreement, which starts off the relationship. There might be the need to submit a purchase order. There might be some standard terms and conditions. There might be further conditions which are included perhaps on a delivery docket or consignment note, or perhaps on an invoice, or perhaps on an account, or any of those documents might refer back to standard terms and conditions. So that's a risk that you need to manage. You need to make sure that they are properly referenced, and that was an issue in one of the cases that we're about to talk about. So where it includes more than one document in your security agreement, you need to ensure that they properly reference each other. And that's certainly an issue. I know there's a few lawyers in the room, but also the accountants in the room. That's something that you need to be working with your clients on, and making sure that you do a PPSA review of their documentation, particularly around supplies, and ensuring that all of the cross-references are kept up to date. Because, again, the PPSA is not a code. You can have a situation where perhaps there is a reference to a standard set of terms and conditions, and that particular document that contains a reference hasn't been updated to reflect the fact that it's no longer the 2007 standard terms and conditions, it's now the 2016 standard terms and conditions. And you can end up in a situation where perhaps the contract is void. It may well become unenforceable because it's uncertain, because the essential elements of it are referenced to something that is now unclear. So one of the good things about the PPS process is that really it's about documentary due diligence. It's an opportunity to go back through business contracts and review them and make sure that they do all continue to stack up and that they're all consistent. Okay, some further key risks. So around signature, I mentioned to you a moment ago that Section 20, subsection 2 requires that the written document, the written security agreement, or the evidence of the security agreement be signed by the grantor. So this, of course, raises the question, well, who is the grantor? This is another point where you need to go and work with your clients about establishing, if they haven't already, clear lines of authority. Who has the authority to sign for certain types of documents? So if you're having goods delivered and the goods come with a delivery docket, the delivery docket requires a signature on the back of the delivery docket, but perhaps with a little notice in bold at the bottom of the front page of the delivery docket that says subject to the terms and conditions on the back. On the back we have a variety of conditions. Well, who's signing that on behalf of the grantor? Is it the storeman? Is it the delivery clerk? Is it the finance manager? Is it the general manager? So the PPSA gives you an opportunity to go back and review your processes and make sure that you're complying with this, because if it's not signed, and particularly from the secured party's perspective, if it's not signed, if you don't comply with Section 20, then your interest can vest. And really, the whole PPSA system, it puts the onus of assessing compliance of these things onto the secured party. So perhaps the storeman who's signing, they don't care whether they're complying with PPSA or not. They probably have no idea what the PPSA is. But as a secured party, it's up to you to ensure that your clients are complying with these obligations as best you can. So in terms of who is signing, who has authority to sign, if we're dealing with a corporation, Section 127 is no doubt familiar to most, if not all of you, and that sets out a way for a corporation to sign a document in terms of 2 directors or a director and a secretary, or if you're dealing with a single person company, obviously the sole director, sole shareholder can sign. Now, where you comply with that, then you've also got certain statutory assumptions that third parties can rely upon. But even if you don't comply with Section 127, if it is the finance manager who's signing or the storeman who's signing, it then turns into a question of general law agency. If they're representing the business, do they have the authority to sign that type of document and thereby bind the business? And so we have statutory assumptions that third parties can rely upon. If they're held out as an agent, then the company is holding them out as having the sort of authority that those types of persons would typically have, unless the other party knows that they don't have that authority. Even if it's not properly signed, so maybe it's someone who's signed it, it is just the store clerk, and they have no authority to sign everything, and they've signed in error, it can still be adopted or accepted by the grantor by subsequent acts or omissions. And so what we've seen in the cases is basically, even where it's been signed by the wrong person, they didn't have authority to sign, the grantor has continued to order stock, has continued to pay for that stock, and then over a period of time we get a course of conduct which shows that they are in fact accepting that. And even aside from PPS, that's consistent with the general law of agency, that if an agent acts outside the scope of their authority, it's then open to the principal to, in fact, ratify their conduct, so by continuing to order the stock. The other key risk in terms of security agreements, and of course this is not an exhaustive list, but another key risk to think about is transfer rules. So one of the rules talks about this is in Section 34, talks about the preservation of the security interest in collateral which is transferred, so from one grantor to another third party. And one of the exceptions to that continuation rule is where the secured party has consented to that transfer. So again, going back and looking at the underlying documentation about, well, what can the grantor do with the collateral? In what circumstances are they able to transfer it? If you're dealing with retail trading stock, for example, of course, it goes without saying that they have to be able to transfer that in order to run their business. So it does depend a little bit on the circumstances, but that's something you'd want to be very careful about, particularly if you're getting into a kind of battle of the forms type issue, where perhaps you're offering to provide credit or you're offering to supply goods on the basis that your standard terms and conditions apply, and then the grantor's coming back and purporting to accept that contract on the basis that their standard terms and conditions apply. And in fact, that was one of the issues in a case we're about to look at. So just making sure that you're not unwittingly consenting to them transferring the collateral to someone else. Now, what I should say is, even if they do transfer the collateral, even if you do lose your security interest because they've transferred it with your consent, presumably if they're selling it, they're then generating a fund which comes back, in which case, as long as you've protected yourself with respect to proceeds, then you're able to essentially substitute your security interest in the goods for a security interest in the proceeds. But again, there's a risk. And the risk is, of course, that, and this is mostly for those that aren't bankers in the room, but where you have a situation where proceeds are being paid into a bank account, then the security interest that the bank has over that bank account trumps everything else, even this so-called PIMSI super priority. All right, but I'm probably getting a bit too technical now. Okay, so what does the Whittaker report say about security agreements? As I said, it's 500 plus pages, 400 plus recommendations. It doesn't say much about the Section 20 issue. One of the things that it does is criticise the current content requirements in Section 20 subsection 2, and basically says, well, the concept of the writing being evidence of a security agreement rather than being evidence of a security interest and a security interest in collateral. So a security agreement might be this long. The relevant provisions that deal with the security interest in the collateral might be on 1 page or 5 pages. So that's the main recommendation, is to completely reshape Section 20 subsection 2 with this proposed amendment. So we'll wait and see what the government says about that. The government, of course, still hasn't responded to the Whittaker report, although the relevant minister did say late last year that they were planning on responding in early 2017. So we'll see what happens with that. So that's the one major recommendation from the Whittaker report. Okay, so I'm going to look at 4 recent decisions to just try and tease out some of these issues that we've been discussing with respect to security agreements. And I'm going to cover these in reverse chronological order. So the most recent case that we've got on the PPS, major case anyway, is Re Carpenter International down in Victoria back in end of March this year. Forge before that here in New South Wales, and then the Gelpack case late last year in September here in New South Wales, and we'll start with Central Cleaning. Central Cleaning being one of the very few appellate decisions that we have on the PPS. Okay, so what was Central Cleaning about? Now I should just start by saying the Central Cleaning case is a transitional security interest case. That's at the heart. The transitional issues are no longer relevant because the transitional period ended more than 2 years ago now. So just bear that in mind. But this case, at its heart, is focusing on what is made up in the security agreement. So there's a number of documents that are being entered into between the parties, and that in fact occurs over a 4-year period. And so at the end of that, when Swan Services goes into voluntary administration and then liquidation, what in fact was the security agreement? So this case concerned Central Cleaning, who was supplying cleaning products to Swan Services. Swan Services signed up to a credit application in September 2009. Now, that was critical in this case because this is about the transitional rules. And the transitional rules essentially said, if you had a transitional security agreement, which was an enforceable security agreement immediately before the PPSA commenced, in other words, up to 29 January of 2012, if you had a transitional security agreement that provided for a security interest either before the Act commenced or after the Act commenced within the first 2 years, then subject to certain exceptions, you had a deemed attached security interest and a deemed perfected security interest. So essentially gave you 2 years to go and register in your own right, if assuming the security agreement lasted that long. Now the trial judge had an issue with how the contracts were entered into, because there was the credit agreement in 2009, there were some supplies that followed that, there was a bit of a break, and then there were some more supplies that followed that once the PPSA commenced, so in 2012. And what the trial judge did was look at the term of the contract that provided the retention of title clause. So that's, of course, where a supplier says, I'm going to supply you with goods and you're going to pay me when you sell the goods or use the goods, generate funds, but I retain title in those goods until the point in time when you either pay me or you transfer them to your customer and hopefully get some money back. So in this case, what they did was they put the retention of title clauses on the invoice itself. So they signed up to the credit agreement. The credit agreement referenced some standard terms and conditions. The standard terms and conditions themselves didn't have a retention of title clause, but the invoices that were supplied with each delivery had a retention of title clause. And there was no issue with was proper notice given or anything like that. It was clear on the terms of the invoice in bold, retention of title clause. The trial judge said, well, each retention of title clause talks about covering only this supply, these goods covered by this specific invoice. And so essentially the trial judge said, well, what we're dealing with here is not one long contract that goes back before the PPS. We're dealing with a series of discrete contracts, albeit contracts that have the same terms because they're all referenced back to the standard terms and conditions. Now, for central cleaning, that was a big problem because if their contracts were after the PPS commenced, then they had no protection under the transitional rules. Now, fortunately for them, that trial judge ruling was overturned on appeal, which was back in May 2015 in the Victorian Court of Appeal. And they said, no, this is all one big contract. And essentially what's happened here is the credit agreement was basically an offer being made by the customer to enter into an ongoing relationship. That offer was then accepted by Central Cleaning actually supplying the goods subject to their standard terms and conditions. Okay, so a couple of important points about this case. One is that it clarifies for us that this term that's in the PPSA that talks about a security interest being created by a security agreement or being provided for by a security agreement. They clarified for us, which we pretty much knew anyway, that if you had a retention of title clause in your supply contract, well, that clearly is providing for a security interest, creating a security interest in the collateral. So there was no problem there. The other issue in this case was looking at the fact that each of the invoices had exactly the same retention of title clause. And basically what the court did was say, okay, we've got some standard terms and conditions, but they don't include the ROT clause, but every invoice has the ROT clause and it's exactly the same. And so, and remember, this is over the course of 4 years. Over the course of 4 years, that ROT clause then gets incorporated into the contract as a standard term and condition. So the fact that it was in every invoice meant that it was part of the standard terms and conditions. Okay, so that was Central Cleaning. The next case, which was September last year, is the case of Gelpack. And this case is also about supplies, although in this case it's supplies that are being used in a process of manufacturing. So Gelpack was a company that was producing plastic products. And in order to produce those plastic products, I have no idea how plastic is made, but it ordered a range of different components, including some resins that were supplied by Primaplas. Primaplas had been supplying to them again since well before the PPSA commenced, going back to 2007. We see the same sort of fact pattern as in Central Cleaning, and so Gelpack signs up to a credit agreement. The credit agreement is referenced to the general terms and conditions of trade. In this case, they did include a retention of title clause in the general terms and conditions of trade. When Gelpack went into liquidation, it owed approximately $1 million for resins which it had used as part of its manufacturing. Now, this case is only the first step, and there doesn't seem to have been a further case, in which case I assume they've settled. What this case would actually be about would be the commingling rules, because they've used a product that was subject to a security interest as part of a process of manufacturing to create something else, and have combined that presumably with products that were supplied by other PIMSI suppliers. So the court recognised at the start that this was just a question of law, basically, as to whether or not they had a security interest, and the commingling issue would be dealt with subsequently. So the other interesting thing about this credit application, aside from being referenced to the general terms and conditions and including the ROT in those general T&Cs, was this provision here, which allowed Primaplas to change the terms of the contract at any time with immediate effect. Now, they then said in the contract that they would use their reasonable endeavours to notify customers before exercising that power, but that was not a condition on the exercise of the power. So they could change the terms and conditions at any time without notice. Now, of course, this is also well before the unfair contract terms regime in the Australian consumer law, so we need not go down that path. So then, after the PPSA comes in, Primaplas decides to undertake a review of their contractual arrangements, so they're doing the right thing here, and they recognise that they now need to change their standard terms because they need to adopt the PPSA language. And so they then, firstly, go off and register a purchase money security interest against Gelpack. They don't tell them, they just do it. Then 2 months later, they write to Gelpack and say, oh, we've reviewed our contract for PPSA compliance. These are the new standard terms and conditions. So forget about the 2007 standard terms and conditions. These are the 2012 standard terms and conditions. And of course, they include a security interest. They include a security interest, in fact, over real property, over all present and after acquired property, and also a PIMSI security interest. So using the PPSA language there. And the letter that was sent to Gelpack then requested Gelpack to sign and acknowledge agreement with those new terms and conditions, noting, of course, that they already had the power to do this. They didn't need consent, but they were asking for consent because the 2007 terms already allowed them to change the terms at any time without notice. So Gelpack then signs the acknowledgement, but interestingly, the credit application in 2007 was signed by the finance manager, whereas the written acknowledgement in 2012 was signed by the operations manager. And this was then used as an argument to say, well, the operations manager didn't have authority to sign this contract. So the issue then was determined. Well, the court said the operations manager would have had authority to sign that type of acknowledgement. And that's because when they looked at what the operations manager did, their job was essentially to negotiate supply contracts. And as part of that, they had previously signed these contracts. They had seemingly total authority to negotiate price and quantity. And so the court said they would have had authority. But even if they hadn't had authority, the court then went on to say that the fact that Gelpack continued to order stock when it was then aware of the new standard terms and conditions and continued to pay for that stock when new invoices were issued and the new invoices made reference to the new terms and conditions, that of course was acceptance by Gelpack. So in this case, Primaplas had a perfected security interest. There was no problem with the Section 20 compliance because the operations manager did have authority to sign the contract. All right, and then this brings us to a case that's gotten quite a lot of attention. You might have even been to some seminars that have talked about this case. It's been reported in the press fairly extensively, in part because it involves tens of millions of dollars. This is the Forge Group Power case. Forge Group, of course, a large mining service contractor involved in a range of other areas of operation, collapsed into insolvency last year. In this particular case, what happened was Forge Group Power had entered into a contract to build and maintain and operate temporary gas turbine power facilities out near Port Hedland. And that was supposed to last for about 3 or 4 years. Now, there was some terms in there that enabled the term to be extended, but it was only ever meant to be temporary. That's critical to this case. So in the contract itself, it says this is temporary. So how did Forge Power do that? They went off and entered into a fixed-term lease with General Electric, which is, at that stage, was one of the world's largest suppliers of these types of equipment. The contract with GE was for a fixed term. The contract with GE specifically said at the end of the term, or if the term gets terminated early, it's a legal obligation of Forge to then return the turbines to GE. So this was only ever meant to be temporary, both in terms of the power contract and in terms of the leasing contract. Now, it took the better part of a year to install the gas turbines on the site, and shortly after they were installed in February 14, Forge Group went bust. So Horizon Power didn't get the benefit of them for very long. The two key issues in this case were whether or not GE was a PPS lessor in terms of it was regularly engaged in the business of leasing, and of course this was a long-term lease that extended over several years. So even though it wasn't a finance lease, it was an operating lease. In this case, it was deemed to be a PPSA lease and therefore a security interest. That was the first issue. The second issue was, even if it was a PPS lease, were these generators fixtures? And if they were fixtures, then they were excluded from the operation of the PPS because of Section 8. Now, just to give you a sense of what these look like, the court actually included diagrams of the equipment. So I didn't include the diagram that showed how they were delivered, which was on very large trailers. But what you can see here is that even in the operational phase of these generators, they're still on wheels. There's temporary supports, although I would just note that they did need to lay a concrete foundation in order to rest them. They're on absolutely flat ground. But what's not shown here is they are also attached to the concrete foundation by way of heavy steel cables, because apparently this particular location was subject to tropical cyclones. And so they were physically attached to the land, even though they were on wheels. So you can kind of see where we're going with this in terms of fixtures. Okay, the first issue. So was this a PPS lease? So the PPSA talks about broadly two types of security interests. And in substance security interest, so that is the purpose of the transaction is to secure the payment or performance of an obligation. On the other hand, we've got deemed security interest. Even if the purpose is not to provide security, if it's a PPS lease, then it's deemed to be a security interest. And a PPS lease is basically a long-term lease. So following amendments in October 2015, we're now looking at a 12-month period in terms of being a long-term lease. So in this case, the equipment was clearly leased for more than 1 year, and therefore it could be a PPS lease. However, GE tried to argue that it was not regularly engaged in the business of leasing this type of equipment, or leasing goods generally. One of the things that GE did in this case was, towards the end of the year, for various reasons, they engaged in a restructuring, so that basically they separated the legal title to the generators and they placed that in one subsidiary company, and they had the leasing contract and the benefit of the leasing contract remaining in another separate company. So they tried to argue, well, if you just look at this specific company, well, this is the only transaction that this specific company has done, and therefore it's not regularly engaged in the business of leasing. The court saw through that, and basically one of the significant points of this case, and I should note that this has gone on appeal, and it's gone on appeal, I believe, on this point, amongst others, but one of the significant findings was the court saying, well, actually, we can look at the international activities of the secured party to work out whether or not it is regularly engaged in the business of leasing. And of course, looking at the broader GE group, thousands of these transactions every year. Even within Australia, different GE companies, as you all know, were regularly engaged in the business of leasing. One point that I thought interesting in this case was the recitals in the contract were included in the decision, and the first recital said GE is regularly engaged in leasing. So it's a bit of creative legal argument there to say that they're not, when that was in fact in the contract itself. The other significant point to come from this is the explanation of what regularly means. There's a bit of a divergence in international cases on this. So the New Zealand cases, there's only been a couple of cases that have looked at it, but they've tended to say if it's just a one-off activity, is that really regularly engaged in the business of leasing, whereas the Canadian cases are a bit more flexible. In the Forge case, Justice Hammerschlag has clearly sided with the Canadian view and has said that the New Zealand authority is a bit too restrictive. So you can have a situation where it's only one transaction, but that transaction is the business of that particular party, in which case it is regularly engaged in the business. It doesn't have to be more than one leasing transaction. Okay, and then on the second issue in terms of fixtures, so the argument was, well, these are physically attached to the land, and so therefore they're fixtures. The court said, well, what does it mean to be affixed to the land for the purposes of the statutory definition, and they said essentially we go back to the common law. So there's quite a lot of cases over well over 100 years about how do we determine something is a fixture, in other words, part of the land, running with the land, or something is a chattel, it's a movable that we can take away from the land. And the leading case is the Coronio case here in New South Wales back in 1938. I won't read through that. Essentially, what they're saying there is, what's the purpose of this particular item being attached to the land? Is it attached to the land so that it will stay there, in which case it's a fixture? Is it attached to the land because it will improve the land, in which case it might be a fixture? Or is it attached to the land simply because this individual item will work better if you attach it to the land? And of course, that's what we're talking about here. Now, the court went through a range of other considerations, but that's essentially what it boiled down to. Again, coming back to the security agreement, the fact that the lease contract had a specific end date, had a range of obligations to return the goods at the end of the lease period. So there was the objective intention of the parties that these multi-million-dollar gas turbines were not meant to stay in their location. It was only ever temporary. The other point to note, of course, is that the rental cost, even though it was $33 million, that was nowhere near the actual value of these items of equipment, so they weren't exactly gifting them to the power company. Okay, so it wasn't a fixture. They were a PPS lease, and because they didn't register on the PPSR, those turbines vested in the company as grantor. Okay, then the last case we're going to talk about, still going okay for time, good. The most recent case, Re Carpenter International. So this is a really interesting case. It's also a very complex case. So it goes for almost 100 pages, and there's many hundreds of individual transactions involved in this case. But to summarise it, essentially what it's about is Carpenter is engaged in cattle exports, live cattle exports. And so the way that Carpenter runs its business is that it goes off and it negotiates with agents for cattle farmers. The agents who are working for the cattle farmers are known as del credere agents, and that's a specific type of legal relationship. And essentially what that means is that not only is the agent representing the sellers, that's what an agent does, they represent someone else and help them enter into a contract, but they also provide a form of guarantee that the purchaser will actually pay. And so the agent will take a commission on the value and will often then pay the vendors, and then they take the seller's rights and they can exercise those rights against the purchasers because they've guaranteed the payment to the sellers. So that's a del credere agent, and that's what these agents were. So, as I said, there's hundreds of individual transactions, and that also meant hundreds of individual contracts. And one of the issues here was actually which contracts applied. And the court spent quite a lot of time going through what's called the battle of the forms. And essentially where they got to was the problem for Carpenter is that their standard form contract didn't make commercial sense, basically. They gave themselves all the rights in the transaction, even where it wasn't commercial to do so in terms of maintaining title to the cattle before they got possession. And so the court said, well, we're not prepared to accept that that is in fact the contract that regulated the relationship. And in fact, that's not the way the parties actually dealt with one another. So just because it's in your agreement, if there's a competing contract which you've signed, which makes more commercial sense and is consistent with how you actually deal with each other, then the court is open to go with that one. And of course, it's all assessed on a reasonable person objective basis. Okay, so it was the agent contracts that applied. The agent contracts largely had security interests by way of retention of title, but not all of them. One of the agents, in fact, didn't put in PPS security interests in their contract, and what they tried to argue was, oh, well, we didn't need to because there was a general industry standard form contract and we just assumed that that applied. Now, you can incorporate the terms of your contract by reference to a general standard contract, and you can put so explicitly. You know, this includes all the terms and conditions, this contract, this version, etc. The problem for these agents is that they didn't do that. What they did was they specifically included only some of the industry standard terms and conditions. and they didn't include others, including the ROT clause. You'd argue the most important clause they didn't include. And so they clearly stuffed up on that one. Okay, so the problem for those agents was, therefore, they didn't have a security interest. So that meant that the cattle that they supplied to Carpenter owned. It was simply a sale of goods, and therefore they were just an unsecured creditor. The other agents who did have a security interest by way of a retention of title clause, though, they had some interesting issues. So one of the interesting issues was that they registered on the PPSR, but they registered on the PPSR too late. So just in terms of vesting under PPS, we've got two types of vesting on insolvency. One type is under section 267 of the PPSA, and that says, essentially, if you have not perfected your interest and the grantor goes into liquidation, VA or bankruptcy, then your security interest vests in the grantor. That wasn't the case here because they did register. The second type of vesting rule is in the Corporations Act, so it only applies where the grantor's a company. And that rule says, and this is really important and has come up in quite a lot of cases, this rule is under 588 FL, and essentially that says once a security agreement is entered into, once it becomes enforceable, you've got a 20 business day period within which you have to register. And if you don't register within that 20 business days, and then the company goes into administration or liquidation within 6 months, and that happened here, they actually went under pretty quickly, then your interest will vest. Now, there is a way around that. The way around it is to apply for an extension of time under section 588 FM. And that's actually the section that's given rise to the most number of PPSA cases since it's been introduced. There's about 20 cases on 588 FM. The problem in this case, though, is that 588 FM says if you didn't register on time because of inadvertence, and the evidence in this case from the agent's managers was, well, we didn't register because we, within the 20 business day period, we didn't register then because we thought we could wait later. And the court said, well, that might be inadvertence, but then the problem was in some of the contracts, they then waited many months later when they'd said, well, we didn't think it was when the contract was originally signed, we thought it was when the money was paid, or we thought it was when the cattle was transferred. And the problem was that they didn't register, in fact, until 2 hours before the company went into administration. So it's not as if they just went off and registered promptly. So the court said in that case, we're not convinced that it is mere inadvertence. We think you made a commercial decision not to register, and then when you saw the company was going under, then you registered. Well, that's too late. That you don't have the benefit of the extension. That's quite a significant point here. The other significant point on this time period is, in fact, when they registered, because what we've got here is a difference between Eastern Standard Time and Western Standard Time. So basically what happened was the administrators were appointed at 4:45 Western Standard Time. Well, that was 6:45 Eastern Standard Time. In between then, the agents went off and registered on PPSR, which was 5 p.m. Eastern Standard Time, or an hour and 45 minutes before. And the argument here was, oh, well, really it should be the whole day. The court said, well, no, it's talking about a specific event. And okay, this might have been very close, but that's still before. Now, in the end, it didn't help them. They registered, which meant that section 267 in the PPSA didn't apply. That's the if you don't perfect, it vests. But the problem then was it was still more than 20 business days and they didn't have the relevant inadvertence there. So that was the problem there. So the last important point from this case is, again, really looking at the nature of the contract, because what the agents tried to argue was that the timing should only begin to run not when the original contract is signed, because a number of things had to happen here. So the cattle had to be tested, put through quarantine, Carpenter had to inspect the cattle and make sure that they actually were accepting the particular heads of cattle, and they had the power to reject certain cattle. So the agents argued, well, we don't even know what the exact collateral is. So therefore, how can we go and register? Surely it's only once everything is settled, that's when the 20 days should run. And the court said, no, that's not commercially workable, because in this case, you've got a series of transactions. In some cases, you've got the vendors assigning their rights to the agents. In other cases, not. It'd be difficult to determine. And, of course, you can register before you have an attached security interest. So that's one of the benefits of the current system, is that even while you're negotiating a contract, you can still go off and register at that point. All you need in order to register on the PPSR is a reasonable belief that you either have a security interest in the collateral that's covered, or that you will have a security interest in the collateral that's covered. And they said in this case, it was a long course of dealings. They knew, okay, whether it's going to be 540 cattle or 545 cattle or these cattle or those cattle, there will be some cattle. This is an ongoing series of commercial relationships. So it would have been open to the agents to go off and register well before, and therefore they would comply with the 20 business day rule. So this case is really about the contract, the underlying contract, and then how the PPSA applies to that contract, particularly with that 20 business day decision period. And this, over the last couple of years, has been catching a lot of people out because, of course, that's much shorter than the earlier time period of 45 days that used to operate under the Corporations Act with the ASIC charge register. So you need to be mindful of that 20 business days. Okay, and that's caught up on the last year's worth of security agreement cases.